All right. This is the People versus Sunny Roundtree. Ticket number P1345080, count one, loud music from motor vehicle more than 10 feet away. Warning, please say your name for the record.
Paul Faulkner, representing the defendant. Your name, sir?
Sunny Roundtree.
Your Honor, this is a
Tamika
trial.
Horn appearing, I'm sorry, Tamika Horn appearing on behalf of the city of Detroit, P70303. I also have our complaining witness here. Officer, please state your name for the record.
Sergeant Cedric Dunbar, 7th Precinct, Detroit Police.
Thank you.
Your Honor, there's an offer. My client would plead guilty. It would be a delayed sentence, and the case would be dismissed upon payment of cost.
Mr. Roundtree, I didn't hear you say your name. Say your name, sir.
Sunny Roundtree.
Okay, raise your right hand. Be swear or affirm to tell the whole truth and nothing but the truth.
Yes.
Put your hand down. You've had an opportunity to speak to your attorney in private about your case and your rights.
Yes.
Has anyone threatened you, forced you, or promised you anything of value in exchange for your guilty plea today?
No, Your Honor.
You're pleading of your own free will.
Yes, Your Honor.
You're pleading guilty because you're actually guilty.
Yes, Your Honor.
You understand that by pleading guilty, you're waiving your right to trial.
Yes, Your Honor.
Knowing that you're waiving your right to trial, you still wish to continue with your guilty plea?
Yes, Your Honor.
I'm going to direct your attention to May 4th, 2022 at 11:07 p.m. on that date and time were you at or near the location of Lafayette and Shane in the city of Detroit?
Yes, I was, Your Honor.
Were you driving a 2011 Ford vehicle?
Yes, I was.
And was there loud music from your motor vehicle that could be heard more than 10 feet away?
Yes, Your Honor.
Is satisfied, Mr. Faulkner?
Satisfied, Your Honor.
Court's also satisfied the factual basis will accept the admission with proceed to sentencing. This is a 3-month delayed sentence. Mr. Roundtree, there's gonna be a $200 fine. You need to have this fine paid by January 20th, which will also be your next court date, January 20th at 8:35. If you pay the fine, you've not gotten any more tickets or citations, so essentially no further police contact. This will be dismissed off your record. Do you understand, sir?
Yes, Your Honor.
Did you have any questions?
I
No,
do, Your
ma'am.
Honor. The offer was that whenever he pays the money, the case will be dismissed. Not at the end of 3 months, but if he paid it today, it'd be dismissed today, or whenever he pays it.
I see Ms. Horn nodding her head, so that seems to be correct. So the court will indicate that dismissal upon payment.
You understand that, Mr. Roundtree?
Yes, I do.
Does he still need to appear on that date, Your Honor, that you've given?
Unless he pays it before then. If he doesn't pay it until then yes.
Okay, well, I'm gonna have it paid before then, Your Honor.
Okay, go ahead.
You need to contact the courtroom the day that you pay it, so we can go in and dismiss it that day that you pay it. Because I wouldn't have any knowledge of what day you may have paid it.
Do you have a phone number he could call, Louis?
Courtroom 965
965
2290.
2290. So do I go to a kiosk or do I come inside the 36 to do it?
You can go to a kiosk.
Okay. So when I go to the kiosk, I just call this number after I make the payment?
Yeah.
Yes.
Okay. Okay. Thank you. Thank you so much, Your Honor.
You're welcome. Good luck to you, sir.
Okay.
Are we ready on Ashton Ray?
That's the trial.
That's going to be a trial.
Judge, you can call it. I have a question, almost like I guess a cop's evaluation. It may not be a trial.
Your Honor, first, are you done with House Counsel?
Yes, we are. Thank you, Mr. Faulkner. Thank you.
My
Officer
pleasure,
Dunn.
Judge.
It has been a pleasure. It's been a rough
Always
pleasure.
mine, Your Honor.
Yeah. They grouped, got the D's together. They got your R's. R's probably one of them.
Mr. Morgan, do you have that file? He does have a file, Mr. Morgan.
We'll bring that back right away.
What, Mr. Hill, you said you needed something before we started, or what do you need?
I was gonna ask for, I guess, a kind of hybrid COBS evaluation, if the court would allow me to make a request.
Okay,
Judge, the current offer is a 12-month delayed sentence. Now, there is, we're contesting the facts in this matter as to whether or not my client was semi-nude, but my question is this. The city's not willing to deviate. My client is 23 years old. She currently works at a special needs school, working with, I believe, children. And she has aspirations of applying to, I think, Oakland County Community College. The issue that I have is while this matter is pending, or while this matter, the 12-month period will show up as a conviction. And I've had clients that have had issues obtaining student loans while the conviction is showing. There's been recently a change in the law, and it allows, it's section MCL 771.2, which allows the court after half the, I guess, probationary period to discharge a defendant if they're in compliance. I would ask the court, my client will avail herself of the offer and plead guilty if the court would be willing to set it for a 6-month review date. And it's completely in the court's discretion, because it is a non-reporting probation, usually a delayed sentence. If the court would allow us to terminate or file a motion to terminate after the 6-month period.
well, the only thing is that the offer, it's the people's offer of the 12-month delayed sentence. So,
Yeah, Your Honor, this prosecutor, my understanding too on a delayed sentence is that, and before it's dismissed, that you would have to have the approval of the prosecutor. That's what's in the law, to my understanding. Now, Mr. Hill just indicated that there was some change in the law, which I haven't reviewed yet.
No, Stephen, so the 771.1 does not require prosecutorial approval. There's case law that suggests that it does. And I'm being very transparent.
I guess my thing is that the prosecutor's office is offering that if this is held, held under advisement for 12 months, then they'll dismiss it. That's their offer. But you're asking if we could come back sooner, 6 months to dismiss it, without even asking the prosecutor if they are in agreement with that or not. But I mean, my thing is that this is all of their offer. I don't think that the court at this point can deviate from their offer, because they're the ones that's offering to dismiss this.
I do understand the court's position. Every judge interprets 771.1 differently, but my opinion is the court has authority to do it without the prosecutorial approval, although there is case law that suggests otherwise. I just know with that new statute for that probation, it allows the court to terminate after half a probationary term has been completed. I've never had a case where I've asked them to terminate early when there's been a sentence agreement, so to speak, but that's the only reason why I asked the court. All I'm trying to do, Judge, is my client is no longer dancing. I've told Mr. Morgan this. After this date, she's never gone back into any type of establishment. All I'm asking is that she has to basically put her life on pause for a year. I was asking for a reduction and a delay. And I understand they have policy. I don't agree with the policy whatsoever. I think it should be a case-by-case basis. I was just asking the court for some deference, that's all. But I understand that the court's position, I do.
All right, so with that, how are we proceeding?
If I can just have 2 or 3 minutes to talk to my client to prepare for trial, Judge, I think that's what we're going to end up doing.
All right, Your Honor, I would need some time to talk to my witness as well.
Stephen, did you send me a copy of the original ticket?
I thought I did.
Okay, if you did, great. And this, if you have the.
Did you have it? No, let me make sure that you have it. Okay. I'm going to send it to him.
You can go in room number 3.